Welcome, everyone. We're thrilled that you can join us for today's panel discussion. Before we start, we have a few housekeeping notes, but first I will deliver the land acknowledgement. We want to acknowledge and recognize that this country is the traditional territory and home of many diverse First Nations, Inuit, and Métis people. Some of the moderators and panelists in today's webinar are in Toronto, located on the territory of the Anishinaabe, Mississaugas, Chippewa, Wendat, and Haudenosaunee peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. One of the moderators is in Peterborough, located on the territory of the Anishinaabe and Huron-Wendat peoples. We acknowledge that Peterborough is covered by John Collins' Purchase of 1785. We honor these peoples and all First Nations, Inuit, and Métis people for their important contributions to this land and to the fields of intellectual property, traditional knowledge, and cultural expression. We encourage you, wherever you are sitting, to take a moment now and throughout your day to consider your own position, the land to which you are connected, where you come from, and your place in reconciliation.
Hi, everyone. In terms of housekeeping, your audio has been muted to avoid background noise. You're invited to submit your anonymous questions using only the Q&A button on your screen. Please do not wait until the end of the webinar to send in your questions, as we may run out of time to answer them. This webinar qualifies for 1 hour of Canadian CPD credits. For Ontario, 1 hour can be applied towards the 9 substantive hours of continuing professional development as required by the Law Society of Ontario. For other provinces, consider including this 1 hour course as a CPD learning activity in your mandatory annual continuing professional development plan as required by the local Law Society. This webinar is being recorded, and the recording will be emailed to all registrants within a few days. Any feedback on this webinar or suggestions for future topics can be emailed to events@lexisnexus.ca. So now I'll introduce our panelists and moderators. Mark Davis is a partner at Castles Brock in Toronto. He is an accomplished intellectual property litigator, certified as a specialist in intellectual property in all 3 main areas of IP, so patents, trademarks, and copyright, by the Law Society of Ontario. Mark offers significant experience in patent and trademark litigation, including in proceedings involving pharmaceutical and biologic products under the Patented Medicines Notice of Compliance regulations, as well as in anti-counterfeiting, trade secret and breach of confidence, copyright, and industrial design disputes. Mark has successfully argued numerous precedent-setting intellectual property cases at trial and on appeal.
Joe Murphy is a partner in the intellectual property group of Potomac Law. A registered patent attorney, Joe has over 20 years of experience practicing in all aspects of patent prosecution, including patent reissue and re-examination proceedings. Joe's practice also includes international patent prosecution, as well as opinion work, including validity, invalidity, infringement, and freedom to operate opinions, and preparation of paragraph 4 notice letters for ANDA filings. Joe is experienced in diversified technologies, especially in the biotech, chemical, and pharmaceutical arts.
I'm going to introduce my fabulous co-moderator, without whom this session would not be possible. So Marcelo Koenigsarkis, a professional engineer, is a registered patent agent in both Canada and the United States and the founder of Prima IP. He is also a registered service provider with key innovation funding programs, including IP Ontario, Elevate, and Accelerate. With over 30 years of experience, including involvement in landmark pharmaceutical patent litigation, Marcelo advises startups, SMEs, and multinational corporations on the protection, management, and enforcement of their intellectual assets. His experience spans diverse industries such as mining, automotive, including EVs, pharmaceuticals, and medical devices. As a licensed professional engineer in Ontario, Marcelo is widely regarded for his ability to align deep technical knowledge with strategic IP planning, both in Canada and internationally, through his extensive professional network.
Thanks, Lorraine. Lorraine Fleck is a general editor of LexisNexis Canada's Internet and Technology in Canada newsletter. As an Ontario lawyer and Canadian registered trademark, she advises businesses on advertising and marketing, artificial intelligence, risk management and information technology, intellectual property, privacy, and adjacent regulatory matters impacting brand and corporate reputation on a domestic and international scale. Having over 20 years experience in intellectual property and technology law, Lorraine also helps companies protect their brands, including in litigation, and negotiate tech-related agreements. A frequent speaker and published author, Lorraine is known for translating complex legal issues into practical strategies using a commercially and reputation-sensitive approach.
We would also like to thank LexisNexis Canada for sponsoring this webinar, and especially Frank Griggs, Content Development Associate, and Monica Sorensen, Senior Marketing Manager, for their help in the promotion and organization of this event.
So now we're going to slide 2, today's agenda overview. The prevalence of generative artificial intelligence in many businesses and academia has made way into creativity and innovation. The impact and legal implications of generative AI and intellectual property, in particular patents, will be the focus today. Before starting our panel discussion, we would like to hear from you, the audience. And so we have 2 polling questions. The first question is generative AI currently being implemented in your business or your client's business? And the second question, if yes, have you dealt with any legal aspects of generative AI? And there we have the results. Very good.
It's interesting, yes.
Yes.
So we're going to get into the questions. So I'm going to throw the first pitch to Mark. So Mark, could you please provide us with background to the global Thaler Dabas as Inventor litigation and summarize the recent Canadian Patent Appeal Board decision?
Thanks, Lorraine. I'd be delighted to, and thank you, Lorraine and Marcelo, for having me here. I was really delighted to hear about the high level of attendance for this, and I think it's a testament to the legal industry struggling with AI and specifically generative AI across the board. It's not unique to patents, but certainly it has a particular application in the patent space. If you've been reading the newspaper, you know that we're bombarded on a daily basis with news about AI and its impact on almost every facet of our lives. This morning, I read that NVIDIA has become the world's first $5 trillion company with a valuation based on strong sales, including $500 billion in confirmed sales for its artificial intelligence chips. That's an increase in $1 trillion over the last 3 months. And I see from the survey, only about half of the respondents are currently using AI in their practice, or their clients are using AI. I suspect very much that number will continue to grow. Interestingly, I read the article on NVIDIA in The Economist, where I also had the option to have it read to me by an AI narrator. There's lots AI can do, but the operative question before us today is, can AI be named as the inventor on a patent? The answer is no, and the webinar is over. I wish there were not more to say on the issue, and it's never quite that simple. It is a new, but not a novel question, a little patent joke, and we have Dr. Stephen Thaler to thank for bringing this issue forward so persistently around the world. For those of you who don't know, Dr. Thaler's a bit of a celebrity in patent circles. His work on AI began decades ago, and he's filed and obtained his own patents on artificial neural networks and network architecture. But over the last decade, he's produced an AI paradigm called DBUS, a device for autonomous bootstrapping of unified sentience. And he's used DBUS to generate inventions. He was named one of Managing IP's top 50 most influential people in 2020, and he's filed patent applications around the world challenging the proposition that only humans or natural persons can be named as inventors on a patent application. In light of the subject matter we're discussing, I asked Copilot to provide me with a timeline of the DBUS patent applications. And I checked it out, as one must do, to make sure it was accurate and complete. The story began in 2018. He filed 2 European patent applications and then converted those into PCT applications in 2019. In 2020, Australia rejected one of the applications and stated that AI can't be an inventor under the Australian Patent Act. Also in 2020, and these proceedings have been percolating up through the courts in various patent offices and the courts in various jurisdictions. Also in 2020, the UK Court of Appeal upheld the UK IPO's rejection of the patent application and held again that only a natural person can be an inventor. 2021, the Australian Federal Court ruled in favor of Dr. Thaler and said AI can be an inventor under Australian law. That, however, was quickly corrected, and Australia, like most other jurisdictions in the world, except for South Africa, and as you'll see on the slide, South Africa being the outlier, it was the first country to grant a patent listing DBUS as the inventor. And that's for reasons of a lack of substantive examination in South Africa. By December of 2021, the EPO Legal Board of Appeals had rejected Thaler's appeal, and it again held that inventors need to be natural persons. Various decisions around the world, we come to Canada, and I'll let Joe speak to the position in the US. But we come to Canada, and let's focus on Canadian patent application 3137161, which Dr. Thaler filed based on a PCT application for the invention entitled Food Container and Devices and Methods for Attracting Enhanced Attention. The patent relates to the profile of the wall of a container that has a fractional profile with pits and bulges. This corrugated profile enables multiple containers to be coupled together by interengagement of the pits and bulges. And if that wasn't enough, it also states that the profile improves the grip and heat transfer of the container. And if that still wasn't enough, there's a pulsating light on top to attract even greater attention to this device. If you want to read an excellent article describing the progress and ultimate rejection of the 161 patent, which is, and you should look at the 161 patent, described as having an unknown inventor, Lorraine has nicely summarized the history and the decision in the August 2025 edition of Internet and Technology Law in Canada. So here's what happened. The Canadian Patent Office got the application, and they asked for clarification on certain issues. Dr. Thaler responded. He filed an affidavit that identified him as DBUS's legal representative and explaining why DBUS should qualify as an inventor. The Commissioner of Patents referred the issue to the Patent Appeal Board, and the issue before the Patent Appeal Board was whether a valid inventor had been identified and, by extension, a valid applicant. And this is given that the applicant's rights to file a patent derive from the inventor. The Patent Appeal Board recommended, and the Commissioner adopted the recommendation, that Inventor, the term as used in the Patent Act, is limited to a natural person or natural persons. Since DeBus was an artificial intelligence system, it couldn't be recognized as an inventor, and therefore the application couldn't be filed by the inventor's legal representative. And a valid inventor cannot be identified according to the requirements under the patent rules. So the application was refused by decision dated June 5th, 2025, and Dr. Thaler and DeBus have 6 months to appeal that decision to the federal court. It's an interesting decision because a lot of ink is spilt over what seemed to be, in my reading of it, a foregone conclusion. The Patent Appeal Board found that the determinative issue was whether the term inventor, as used in the Patent Act or rules, included an AI system. And if not, there was no valid inventor or inventor's legal representative, and therefore no right to apply for a patent. You'll know that the term inventor is not defined in the Patent Act or the patent rules. And so in conducting its analysis, the Patent Appeal Board went back to first principles and embarked on an exercise of statutory interpretation. They looked at the Vavilov decision of the Supreme Court of Canada, the modern principle of purposive construction. They looked at the fact that the words in the statute must be read in their entire context. Now, there's been a Patent Act or federal legislation for patents in Canada for over 150 years. And you can be sure that Parliament at that time did not expressly or implicitly address the issue. As the Patent Appeal Board points out, patent law is purely statutory, but we also know that Canadian courts have approached patent issues based on the bargain principle, full disclosure of the invention in exchange for a limited time monopoly over new, useful, and non-obvious inventions. It's not the first time Canadian courts have been asked to resolve issues relating to patentability. The Onco mouse that was the subject of the Harvard mouse decisions of the Supreme Court of Canada over 20 years ago also considered whether a higher life form could be patented, and in a 5-4 split, the Supreme Court of Canada ruled that higher life forms were not patentable subject matter. So all of that informed the Patent Appeal Board's decision. It looked to earlier cases, the Apotex and Wellcome decision on AZT, and the use of a known compound to treat AIDS. It looked at the test for who was a co-inventor that the court considered there, found that while not deciding the issue, courts had struggled with inventorship and come to the conclusion that it required a natural person to be the inventor. There was also, for those who are interested in obscure legal doctrines, an argument that was raised by Dr. Thaler about accession. And if you go back to Roman law, this basically means that if your goat has a baby, you own the baby. Or, if your property increases somehow, your property, you own that increase in the property. And the court rejected this argument, saying that that wasn't a principle that had been incorporated into Canadian law. So ultimately, the answer to the question that the Patent Appeal Board came to of whether AI can be named as an inventor on a Canadian patent application was a resounding no. And since that's consistent with almost every other jurisdiction in which the issue has been considered, I strongly suspect that it's going to stay that way if an appeal is brought.
Thank you, Mark, for providing us with that summary. I'm now going to ask Joe if you can summarize the U.S. position regarding generative AI as inventor.
Sure. Thanks so much, and good afternoon, everyone. And it's great to be speaking with everyone. And thanks so much, Marcelo and Lorraine, for inviting me to be on the panel. And Mark, that's a really great rundown. Thanks so much. So today I'm going to be giving you an overview of the AI and its nexus with U.S. patents and the patent prosecution process as far as inventorship goes. This is a rapidly developing area of law. so we have to keep an eye on its development. So let's take a look, if we go to the next slide, at patent requirements in the U.S., specifically with regard to inventorship. So relevant for today is that an application for patent has to include the name of the inventor for any invention claimed in the application. And interestingly, an incorrect naming the inventive entity, that is the inventor or inventors, can lead to a patent being found invalid or unenforceable. For example, if a misrepresentation is made to the USPTO, while inventorship can sometimes be corrected in a patent, it can, of course, and it can be corrected during pendency of the application, and may change based on restriction requirements or amendments during the prosecution of the application. It's done on a claim-by-claim basis. Correctly naming the inventorship is critical for the patent application process and the continued validity of patents. So what are the issues we'll be looking at today? If we go to the next slide. Oh, do you have, Lorraine, could you, oh, there, thanks. So we really kind of two issues today, obviously, which are very important with regard to AI in the context of, again, U.S. patent law. The first is, can artificial intelligence be an inventor on a U.S. patent application? And the second is, can artificial intelligence output be considered patentable subject matter, specifically in the context of whether and how much inventors can rely on artificial intelligence generated output to make their inventions? So we'll look at some case law and we'll look at some USPTO guidance on these issues. So maybe if we go to the next slide. So with regard to inventorship in the US, the key concept is who conceived the invention, so conception. And so basically, unless a person contributed to the conception of the invention, he or she is not an inventor. For co-inventors, each inventor must contribute significantly to the conception or reduction to practice of the invention, really the conception. So can AI serve as an inventor? So let's take a look at the case on point in the next slide. And again, we've got this situation with Dr. Stephen Thaler and this AI system, the DABUS device for autonomous bootstrapping of unified science system. And again, so it's source code or programming and software which can produce AI-generated inventions in quotes. So Dr. Thaler in the US sought patent protection for two alleged inventions and listed DABUS as a sole inventor. Now, this is sort of a formal thing in the US, sort of formality situation in the US. So instead of writing or listing himself as an inventor on the application data sheet, he wrote invention generated with artificial intelligence. So similar, same exact situation. So the US Patent Office concluded both applications lacked a valid inventor and were therefore incomplete. So they were never even picked up for examination. So Dr. Thaler appealed to the District Court for the Eastern District of Virginia, which is where the United States Patent and Trademark Office resides, which upheld the U.S. Patent and Trademark Office. And Dr. Thaler then appealed to the U.S. Court of Appeals for the Federal Circuit, which is a court that hears patent appeals. So we can talk about that opinion here. If you want to go to the next slide. Thanks. So this is a 2022 decision. The Federal Circuit upheld the USPTO decisions to deny naming DABUS as the inventor, and the decision hinged on the interpretation of the definition of an inventor in Title 35 of the United States Code, Section 100F, which states the individual, or if the joint invention, the individuals collectively who invented or discovered the subject matter of the invention. So critically, here the court concluded that the inventor must be a natural person. Now, interestingly, the court further explained that it was not confronted with the question of whether inventions made by human beings with the assistance of AI are eligible for patent protection. So what are the requirements generally to be an inventor in the US? I think we got another slide. Okay. So we see a person who shares in conception of a claimed invention as a joint inventor of the invention. So far we've got two things, right? For inventorship in the US, an inventor must be a natural person, as we've seen, who conceives the invention. And for co-inventors, each inventor must contribute significantly to the conception of the invention. So I think this is where we begin to contemplate the difference between AI as an inventor and how AI can assist inventors, because it raises the question how much AI can be relied upon by an inventor and still have the human be the inventor. So we begin to think about the concept of what counts as a significant contribution. So how we determine what constitutes a significant contribution, we can look at some USPTO inventorship guidance for AI-assisted inventions, which rely on another CAFC, or Court of Appeal of a Federal Circuit case, which is called Panu v. IOLAB, which is a case looking at co-inventorship. That was a case about intraocular lenses for folks with cataracts. And according to USPTO, AI-assisted inventions are not categorically unpatentable for improper inventorship. But the focus of the inventorship analysis requires a significant contribution by a natural person. And again, this is an evolving area of law, so I would say this is the current state as far as the USPTO. This is the guidance that they've got up now. And this Panu case provides factors to consider as to whether contribution is significant. And all that is required of a joint inventor is that he or she contribute in some significant manner to the conception of the invention. As the USPTO writes, each named inventor must have significantly contributed to the definite and permanent idea of the complete and operative invention as it is thereafter applied in practice. Each joint inventor must, oh, I'm sorry, yeah, thanks for the slide. Make a contribution to the claimed invention that is not insignificant in quality when that contribution is measured against the dimension of the full invention. And each co-inventor must do more than merely explain to the real inventors well-known concepts or the current state of the art. So a contribution is significant if it helps define or shape the invention as claimed, even if the contribution relates to only one claim or one feature of the invention. As I mentioned, inventorship of application or patent is really determined on a claim-by-claim basis, and in these situations, kind of case-by-case basis, and each instance turns on its own facts. So someone who only suggests a general goal, or who makes an obvious addition that anyone skilled in the field would make, is not necessarily an inventor. In addition, the USPTO stated that the use of an AI system by a natural person does not preclude a natural person from qualifying as the inventor or joint inventor, as long as the natural person significantly contributes to the conception of the claimed invention. So that's sort of the state of the law in the US right now. Again, the use of the AI system by the natural person does not preclude the natural person from qualifying as the inventor or joint inventor, as long as the natural person significantly contributes to the conception of the claimed invention. Now, it's interesting because this is normally the part where I would go through some examples from the USPTO. And again, it's interesting because the previous administration did have some examples of AI-assisted inventions and inventorship. Now, the current administration that we have took those down and marked them as under review. So, and they have not promulgated any new examples. So we don't really have the current administration's view of what constitutes, the significant contribution and how much contribution a natural person must make vis-a-vis what the AI has done. So there's no real definitive answer at this point. But I think it is safe to say that a person who utilizes an AI system and makes a significant contribution to the output to create an invention may be considered a proper inventor. I think that is safe to say. In addition, the USPTO has provided, or at least it's still up there, several examples of claims that recite the use of AI in the body of the claim. So this goes a bit beyond what we're speaking about today as far as inventorship goes, but, can AI-assisted inventions be considered quote unquote patentable subject matter. And it seems like they can. They are generally viewed, just to speak about it briefly, they are generally viewed almost in the same way that a mathematical formula or an abstract idea would be in the context of a patent claim. So you can apply the normal 101 analysis to that, where you look at additional elements which may make the claim patentable subject matter, or you look for significantly more that would get it to the realm of what's considered patentable subject matter. So to summarize, I think we have one more slide, or I've got one more slide. From the U.S. perspective, artificial intelligence cannot be an inventor on a U.S. patent or patent application. However, artificial intelligence can be used to assist inventors as long as the natural person makes a significant contribution to the invention. And we've also see that currently artificial intelligence can be an element, a patent claim is considered and can be considered patentable subject matter as long as it meets the other requirements of 35 USC 101. So I think that's where the state of the law is on the US. So maybe we can, go through some questions and further discussion.
Thanks for that, Joe. Just following on that path, Mark, can you give us some insight on the Canadian side? If a natural person is required to be listed as an inventor, is there a minimum threshold of contribution by the natural person for an invention conceived with generative AI?
It's a great question, and I want to talk a little bit about the Canadian law, and I invite Joe to jump in on the U.S. law, because Dr. Thaler obviously set up his patent application as a full frontal assault, right? And I'm not naming an individual. I'm naming the AI system itself as the inventor. And if he'd kept his mouth shut, claimed himself to be the inventor of the wonky containers that can fit together in unique ways, the patent might have gone through. And put aside whether anybody ever would have actually manufactured or used the containers, there was a patentable subject matter, or arguably patentable subject matter there. But I think, Joe, what's interesting about the U.S. guidelines and the inoperativeness of the U.S. guidelines right now is you've got a situation where, for the most part, it's the office confronting these claims and looking at it, looking at the claims to reveal, whether AI is the inventor or not. And what I'm curious about is, whether that's catching the use of AI in terms of drafting patent applications, or whether there's lots of things where the inventors have used AI in some aspect, and then it doesn't come out on the face of the claims.
Yeah, I think it's a good point. It's really interesting. We as patent prosecutors, we're kind of limited. The client can give us an invention disclosure form. We draft it up. They approve it. We file it. They give us a list of inventors. So it may even be invisible to us what role an artificial intelligence played in preparing the applicant, coming up with the invention, quote unquote.
Yeah.
They can't, but coming up with the application to a certain extent. That said, I mean, in the US, at least, we have a duty to disclose all material relevant to patentability. We operate on the rules of professional responsibility, as I'm sure we all do. So if we're aware that we've got an invention that is purely AI generated, and the client's like, oh, I punched this into ChatGPT or whatever, and here's the output. Can you file this for me? That's not even if the prompt is really, even if the inventor gave the query, the prompt, and identified the problem, which I think I mentioned in my part of the talk, that's not enough for invention, right? You've got to come up with the conception of the invention, how to solve the problem. And now I can't really do that, at least at this point. You know, we haven't seen it. You know, we need the natural person to step in, and we need a significant contribution. So yeah, it's a real issue. You know, how much does the client tell us? So what do we even know when we you know sign these documents and send them in the patent office?
No, I think it's a great point. I think too, you know, there's an interesting article that the intellectual property owners organization put out, and it was a joint collaboration between the Software Related Technologies Committee and the AI and Other Emerging Technologies Committee. But it draws a nice distinction in the patent realm between, you know, inventions relating to AI itself. You know, the operating principles, the core technology, things of general application, as being, you know, one category of patents, and those having human or individual natural person intervention, patents relating to the application of AI, right? So it's AI being used to enhance some particular process or whatever it may be. And then, you know, this third category that we're talking about, inventions made using AI, conceived or designed, you know, by AI itself, by AI in collaboration with a human, or, you know, designed by a human with the assistance of AI technology, right? And that legal, the important legal question, what do you mean by that? You know, where does the level of significance come in what in Canada has always been described? Inventorship's always a factual issue that needs to be determined. So, you know, in focusing on that third category, and there's not a lot of case law in Canada involving AI. I mean, none. The Ballard decision and a bunch of legal articles really is all we've got. But we know from the Patent Appeal Board decision that you can't get a patent when AI is the sole inventor. Stands to reason you can't then get a patent where you're naming AI as a co-inventor for the very same, you know, formalistic reasons. The AI itself can't assign the right. And so, you know, the question is going to be under Canadian law, when has an individual, natural person, contributed enough to the inventive concept to warrant the filing of a patent. And, you know, we've got a ton of case law that considers who qualifies as an inventor. You know, the case law says in some way responsible for the inventive concept. You know, depends on the specific contributions made by individuals, has to involve inventive ingenuity, not just verification and routine experimentation. But is there a hard and fast line? You know, no. And the US guidelines would be the best thing that we've got. You know, and I mean, they're not enforced in the US. They're certainly not enforced in Canada. But, you know, we're going to have to come to some consensus around where that line gets drawn, because the alternative is to, as with any factual question, just litigate every single instance as we come to put parameters around it. So, you know, it's like, even, you know, the case laws, even minor contributions can qualify somebody to be a co-inventor. And so when you've got, we know AI is being used as a tool like any other tool by lawyers, by businesses, by pharmaceutical companies doing drug discovery, you know, simulating climate models, energy optimization, self-driving car. I mean, it's everywhere, right? Algorithmic trading, for that matter. And I'm sure, you know, being used to bring forward, coax into the public domain for, when we're looking at a purposive interpretation of Canadian patent law, the sky's the limit for how it can help enhance the inventive process, right? And so, it's a bit of a joke this morning. I asked Copilot to design me a perpetual motion machine, and it told me to pound sand and that it was unable to overcome the law of physics. So I was at least encouraged by that. But it's going to really be an incredible and time-consuming exercise as we find the cases to bring forward to figure this issue out.
There's questions coming down. I'm sorry, I can't follow them. Are they?
Yeah,
I mean,
we can do it
if there's
at the
questions,
end.
Lorraine, and you want to pose them, that'd be great.
Well, so I mean, we have a decision. I can ask the next question, and then we can go to the Q&A, like whatever you guys want to do. I'm pretty chill.
Okay. Well, here, let me. The only other concepts that I want to introduce, and I'm sure we will get there in the discussions, is it's not just an issue, as I see it, of inventorship and the impact that AI is going to have on the assessment of inventorship. It's going to play itself out at every stage of the validity analysis, from what constitutes prior art, what constitutes the common general knowledge, anticipatory references, obviousness, utility. If we look at the utility test, right? Can you demonstrate something is useful or have a sound prediction of utility through AI, right? The sky's the limit in terms of how this is going to play out. So
yeah. Well, how about this? I'm just going to do the next slide, which was me asking Joe. Sorry, I'm dealing with multiple screens here. And then we'll get to the Q&A, which is what we planned anyway, but we're a little bit ahead of schedule, which is good. When using an AI model, Joe, who owns who owns the model and who owns the results and output? And Mark, you might have some input on this too as well from a Canadian perspective.
It's a great question. And of course, the answer to all legal questions, as always, is it depends.
Yeah.
So I think it's more of a contract law case, actually, I think. So if you go on my understanding is like OpenAI and even ChatGPT possibly, like they say that you have the right to use their output and you own it. Some of them do, some of them don't. You have to check that. Yeah. And I would be very leery about, if you use Harvey or some of the other ones, the more refined ones that you have to like sign up, pay money and sign up for, you have to check that. But that said, in the US at least, there's no copyright on an AI output. There can't be, because, there have been cases in the US where someone used AI output, that Zarya the Dawn case. It was a comic book that this a woman wrote. She wrote the text, and then she got the copyright on the text, but she couldn't get the copyright on the images she got from Midjourney. And that's an interesting case, because she hadn't drawn the images. Midjourney had made the images. She kind of chose the ones she liked. So as far as like copyright goes and things like that, you have the right to use it. They can't, there's no copyright in it, so you could use it. Again, can you use it in a patent application, not listed as an inventor, but you could use it like in a background section or something like that. So it's a really interesting, it touches on contract law, copyright law, I think, things like that. So yeah, I don't know, Mark, maybe you have some thoughts on it too.
No, I mean, I think that's exactly right. And, the Canadian legal position is always somewhere between the US position and the English position. And you add a U to the word color when you're discussing it. But it's, I think that's absolutely right. In terms of the results output, therein lies, the issue, right? And on the copyright front, on trademark logos, the advertisements that clients are generating using AI, right? They'd all be shocked to find out that, the starting point is not the same level of protection that they thought they had when this was all being done by humans. And so it's a question that we're asking on a daily basis in areas where you never would have thought you had to ask it before, because you need to know, right? Filing a trademark application for a logo, where'd the logo come from? And was it generated by AI, right? That's relevant all of a sudden. So a little bit beyond the patent context, but I think it's everywhere, right? And
I'll take it, if I may, I'll take it one
Yeah.
more step, even again outside the patent context. But I think it's instructive. You mentioned trademark, so let me mention trade secret. At least in the U.S., there's two requirements for a trade secret, right? It's got to be, you've got to take reasonable steps to maintain the secrecy of it, and two, the value has to be the fact that you're keeping it secret. There's no requirement for inventorship in trade secret. So if you get an AI output that, you can start making money off, as long as you take the reasonable steps to keep that secret, that may be the move. Hey, I can't get a patent on this. Let me just keep it, inside my company, keep it in the vault, and make money on it that way. So that's another thing to think about.
That makes sense too when you start thinking about chemical formulas, right?
Exactly.
And how much
Exactly.
AIs, are used in chemistry to help with
processes.
screening. Yeah, screening. Yeah. So, I think we've come to the end of the discussion part, like the formal discussion part. I'm going to get questions. We have an advanced audience question. So Marcelo, do you want to take that one, and then we'll just
Sure.
go through the rest?
Yeah, we have one question directed to the US, but we can swap out US to Canada, and then Mark, you can also address it. So Joe, do you know if there's any lobbying being done in the US by high-tech companies to expand the definition of inventor to include AI?
I don't know of any lobbying. My guess is a lot of the lobbying may be going on behind the scenes, honestly. So it's interesting to me that this is the one particular area they took down and marked as under review. So that tells me there is something going on in the background. But do I know that? I don't know that for sure.
Okay, thanks. Mark?
I'd be very surprised if there wasn't stuff going on in the background. I mean, you read that Microsoft is investing in OpenAI, and now there are plans to take it from a not-for-profit to a for-profit company. Like the interests are significant, Marcelo, and patent law has been one area that's good at following the money, right? Historically. So I would be surprised if that weren't going on. That said, on the flip side, the AI advocates are all about the democratization of knowledge and the betterment of humanity and the world being a better place, right? And so if we have if AI were to erode patent rights insofar as common general knowledge becomes broader and obviousness becomes, an easier test to meet, and anticipate, like we've got the 5,000 monkeys typing on a typewriter so that every piece of knowledge that could ever possibly be conceived now exists, then Chicken Little is Mark all of a sudden on this discussion, which I'm not sure I really am, but the implications are significant.
Yeah, no, perfect. Thank you. Lorraine, do you want to tackle hand out the next question?
Sure. I'm going to go back to the advanced one question we got when someone signed up. So and this is for both Joe and Mark, will there be different thresholds for obviousness for human inventors and human plus AI inventors?
Maybe I'll take the first swing at the pitch. I don't think we're going to change the requirements. I don't think we're going to change 35 USC, 102 or 103. I don't think those will change. I think it might change. I think it may significantly change what is considered the sort of person having ordinary skill in the art, not necessarily from the person perspective, but how much they know and how much they can foresee. Now you've got these AI models, like you mentioned, Lorraine, about doing screening for compounds, and now you've got AI that can generate these,
Yeah.
millions and millions of compounds, and maybe go through and pick them out and all that stuff, and predict what it would do, as far as binding receptor or having some kind of
Yep.
function, those kinds of things. Those might become far more predictable. Right now, they're sort of unpredictable. You kind of have to test them. It's easier to show an unexpected benefit because you've got this compound no one's ever seen before. And hey, now we can treat this disease and it works great and it's not toxic. So therefore it's an unexpected benefit, that kind of thing.
Mhm.
That may fall not by the wayside, but it may become more difficult to meet that threshold. That would be my concern. I think it's going to make it harder and harder to jump over those barriers to meet. And then, I think, yeah, I think it's just going to make it more difficult. Now everybody's got access to sort of all human knowledge. You go into this LLM and it can make all these predictions and things like that. It's just going to make it way more difficult.
Mark?
So Joe said he'd take the first swing at the pitch. That was a Davis Schneider swing at the first pitch there, out of the park. I mean, I agree with Joe completely. I think the only addition that I had, and it came to me as he was talking, is the authority of AI remains dubious, right? I think that we talk about prior art and common general knowledge as the stuff in textbooks and authoritative articles and everything else. And I'm not sure that I'm convinced AI is there yet. I find it good at telling me things I know. I'm not sure I trust it for the things that I don't know already. And from that respect, there may be some uncertainty there, but I don't think it's going to last very long. And I think we are going to be in a situation where what constitutes common general knowledge is significantly expanded, and the fights will be about the authoritativeness of that information. And as a plug for a litigator who might get a case like this one day, hopefully, keep good records of everything.
Oh, keep records of all this stuff.
Yeah.
Right. Marcelo, do you want to ask the next question?
So we had a question here. Do you think there's any obligation to disclose the role of AI in coming up with the invention in an application?
Again, I like to take the lead off hit, right? In the US, the patent office has said, no, you don't have to disclose that. And obviously, again, we work under the rules of professional responsibility. We have duty to disclose information, material, patentability, all those things. But as far as the guidance that's up there now, my understanding is that you don't have to disclose that, hey, AI was used in developing these compounds or whatever. You don't have to do that. Now, obviously it's different for litigators. You go in court in front of a judge. A lot of judges now are saying, if you use AI at all writing this brief, you have to tell us. USPTO has not done that yet. But you still have the normal, again, professional responsibility to meet. So I think that would be the U.S. perspective, that as far as I'm aware of it today.
I mean, Marcel, you're better qualified to answer it in terms of what's required in the Canadian Patent Office than I am. I think there are lots of examples where the use of AI in the court system, for example, they want it disclosed, right? And that tribunals now are asking for that. Whether that exists or is coming in the Canadian Patent Office, I just don't know the answer to that. But it then becomes a question of, and so what, right? Like what's the issue that's going to speak to, right? Like, and to my question to earlier, it's nobody's, as far as I know, unless somebody raises the dispute, the office isn't looking at whether the inventors are actually the inventors or are not the inventors, right? You know, is the office looking in on utility for, you know, I needed AI in order to, you know, ground my prediction of utility? Or I mean, I think it would be circumstantial where it would have to be disclosed, where it's like relevant to a patentability issue. But I don't know to what end beyond that it would need to be disclosed.
Yeah, I tend to agree. I think it would be more when we're into discovery and looking at the inventors' lab books, et cetera, to establish inventorship, et cetera. Lorraine, do you want to tackle the next?
Yeah, I'll go to the other, go back to the Q&A. So if AI is used to generate an invention, it is unclear if the communications with the AI tool are confidential. Is there an obligation to disclose the content generated by the AI tool in an IDS as the answers may not be private? Also unclear if the grace period would apply as the disclosure originated from the AI tool and not from the inventor or applicant. I chose a hard question.
That's a really, really complicated question. What I would say
I'll let
is,
Joe go first.
yeah, see how I deal with this one. I would say I'd be very leery about putting anything into, just to pick one, ChatGPT or whatever, you know, those things I think are good for like the background section, that kind of thing. When you start getting into the meat of your invention, I would keep that stuff out of the AI world, because I mean, yeah, you can go with ChatGPT and you can click the thing that says, okay, don't use this to train your models. Is what, I don't know. Is it going to do that? I don't know. I mean, you know, so I'd be leery about putting stuff in there that is proprietary, that is confidential. You know, look, you want a definition for something and you could have Googled it, but you use ChatGPT. Okay, that's fine. But no, I would be very leery about putting stuff into the AI models at this point.
Mark?
Yeah, I mean, it's out of your control, right? Completely. It's why we're kicking, you know, note takers out of meetings, because we don't know where that information's going, right? And it's got all sorts of implications.
I did a lecture at U of T this summer, and a classmate of mine went first, like 2 weeks before. I saw all the virtual note takers, and I said, no note taking unless the person like literally has a disability and they can't type, or there's some sort of disability problem. Because, and I actually used, there was an IP workshop, so I used it as a teaching moment to tell that this stuff is not private, right? So that they wouldn't, you know, end up on, you know, on the wrong foot. I think we have time for one more question. Are we at 1:59?
We're already at 1:59, so we do have some great questions coming in, but unfortunately we're out of time. So I'd like to first of all thank all our panelists for participating in today's webinar. You're up, Lorraine.
And thank you also to our attendees and sponsor LexisNexis Canada. We appreciate everybody's contribution. Sorry.
Absolutely. And we hope you found the webinar useful. Thanks again, and have a great day.